Hi guys. Hi. Welcome back to A Justice for All. I think this is episode 21, maybe 22 with Judge Joe Brown. How are you?
Right.
So today, we're going to talk about Diddy, right? This is the end of the 29-day trial, RICO trial of Sean Combs. As of today, Thursday, January 26th, prosecutors are closing their remarks. And tomorrow, Friday, the defense will give their closing remarks. Now, here's the thing the jurors will soon be asked to deliberate over a complex list of charges: two counts of sex trafficking, which is a potential sentence if convicted, a minimum of 15 years, a maximum of life in prison, two counts of transportation to engage in prostitution, potential sentence if convicted, up to 10 years in prison, one count of racketeering conspiracy, potential sentence if convicted, up to life in prison. However, the prosecutors did drop a couple of the charges. So the prosecutors say they will no longer argue attempted kidnapping, attempted arson, and sex trafficking as liability for Diddy's RICO conspiracy charges. So we're right now, starting Friday, we will be on verdict watch. And I
Right.
and I wanted to ask you, what happens when it's at the end of a big trial such as this, closing remarks, and then the jury they get their instructions from the judge, what kind of instructions, and then they go back and deliberate.
Generally, I found it a very, very bad policy to set time limits on how long either side gets to argue. The general rule is that the prosecution, having the entire burden of proof, must put on their initial closing statement. The defense has the option of replying to that, which is what they do. And then the prosecution has the opportunity to rebut that. That's the general course of things. Probably the most important thing that's going to occur right now is the judge charging the jury. That is very seldom dealt with in the press. It's boring to most people, including, unfortunately, to the lawyers involved. And that is when the judge does his thing, because if he gives the wrong instructions to the jury, the trial is essentially never over, and any verdict is invalid potentially if wrong instructions are given out. On a murder trial, the instructions may consist of anywhere from 6 to 10 to 12 hours worth of continuous reading by the judge of written instructions that he's had to put together, draft, craft, whatever the case may be, and include them in the trial jacket so that the jury can continuously refer to them if they choose. There are generally pattern jury instructions that are essentially common law, and they're not subject to statutory dictates. And these pattern jury instructions are used as the judge sees fit. And essentially, there is no one size fits all because trials differ in their circumstances. Sometimes one side or the other abuses the process and drags on at great boring length when it comes to closing arguments, but I always thought that was the better option rather than trying to artificially. Generally, it's rather constricting to say you have so much time to argue. That's a new conceit by a lot of judges that have very little experience in trying cases as trial lawyers themselves, so I don't approve of that. The charges that were dropped are not surprising because, to a great extent, this whole thing against Diddy may be merited in some ways of considering what's going on. But to a great extent, what you're looking at is lawfare, which is something that the Bill of Rights was designed to prevent 234 years ago. And the 14th Amendment, after the Civil War, came into play to apply the same rules to the states when they tried to do it. And in my experience, what I saw, aside from the merits one way or the other with Diddy, particularly the involvement in the Combs matter with the Homeland Security aspect, was to prevent him from being able to speak on certain things that might have been harmful to certain people that were running for election last November 2024. And the involvement of Homeland Security instead of just the FBI allows a defendant to be held essentially incommunicado. That's not a good thing. We have a U.S. attorney who is no longer calling the shots, and that person looked like a foil for the Democratic Party in their interest rather than justice. And we had what we had, and to a great extent, we've got all sorts of outlooks, attitudes, and perspectives on protecting people versus people have to take responsibility for their own actions. And it boils down to something I've always had a problem with, which is the Mann Act. That's basically everything left on the board that they're going after Diddy on, or Combs on. And the Mann Act was created before World War I by basically some racist institutions in the United States that were very offended that black world heavyweight champion Jack Johnson had a white wife, and he was taking her all over the country and the world along with her friend girls, and they objected to a black man being surrounded by an entourage of white women. So that's the purpose of the act. I've defended people charged with it, and it is something that is gravely subject to abuse. And essentially, it's sexist in today's terminologies, and it is directed toward transportation of females across state lines for so-called illicit purposes. Jack Johnson was convicted of it, the first person prosecuted and convicted of it, when he and his lawful wife went across a southern state on their way to a seaport to go to Europe. That particular southern state did not acknowledge interracial marriage, so about 15 minutes into the journey across this state, the FBI at that point, not authorized to be armed and accompanied by U.S. Marshals, rushed the train and arrested Jack Johnson. He was prosecuted and convicted, but he managed to escape, get to Europe, and then his very selfish mother just wanted to see him so badly, and he tried to sneak back in and got caught. Wound up serving the sentence, which was shorter than the one that he wound up getting for the escape episode, and he wound up finishing his time, and he got out of prison and purportedly died in a one-car accident in 1946. This is for something that happened back in 1911. And Barack Obama refused to do anything about it, but President Donald Trump pardoned Jack Johnson posthumously for this. So that is a statute that does not need to be on the books. It does have some aspects of it that are dealing with matters of concern today. And what you have is a dichotomy between people should be held responsible for what they do and the choices they make, particularly when they have options. And then the idea, on the other hand, that people should be protected at all costs, even if doing so allows abuse of the criminal process. So we've got a case that is going to go to a jury with an apparent indication that the defense is declining its right to put on proof if it chose to do so, or to decline without penalty of putting on proof. So here we are. I don't know anything past this point. I will patiently await the outcome of any verdict if the jury can do so without damage to justice or their individual considerations in the process. So let's see what happens.
So I have a question. Why do you think the prosecutors ended up dropping kidnapping, attempted arson, aiding sex trafficking charges in a
I
Diddy case?
called the point of what I just told you. In today's terms, the Mann Act is bullshit. It's still on the books. It's been there entirely too long, but it's there and they're using it. And part of the problem with the whole thing is that we now have a different political situation where the U.S. attorney that was pushing this in collaboration with the Democratic Party, the Biden-Harris administration, in an effort to protect probably Kamala Harris and some other people from embarrassment going back over 15 years of recordations for the activities of these freak parties. They used the Mann Act to bring this whole thing into play, and they covered it by trying to show concern for feminist interest. So it's not surprising that since that prosecutor is no longer in charge of the operation, having turned in his resignation and in the process of being replaced, that some of the more egregious charges were dropped. You see, a prosecution has an interest not just in getting a conviction, but ensuring justice transpires, which may sometimes require the charges be dropped in the interest of justice. So that's apparently what happens. And by the way, the court doesn't have to allow this. It gives the state, the federal government, the option of not arguing, which makes the duty of the jury pretty obvious to decline to convict, or it may accept what usually comes out as, Your Honor, in the interest of justice, the prosecution wishes to dismiss or drop the charges or null pros. That means to stop the prosecution on the charges in question. So there you go.
So it says here, this is a document from the prosecutors. On the 24th, the government understands the court's desire for streamlined instructions. With that in mind, the government has suggested ways to streamline those instructions. Specifically, the government has removed instructions from the charge relating attempted kidnapping under both California and New York, attempted arson under California law, and aiding and abetting sex trafficking. The government is no longer planning to proceed on these theories of liability, so instructions are no longer necessary. While it says sex trafficking and forced labor instructions, while the government has taken seriously the court's desire for brevity, the government still strongly believes that certain limited additional instructions on sex trafficking and forced labor instructions, which are regularly given in sex trafficking and forced labor trials in this circuit, are necessary for the jury to adequately understand the law on these charges.
That's what's up to the judge. He doesn't have to accept that. But see, this also broaches one of the inherent dangers in American laws as it exists today, particularly as to what happened 40 some years ago under Biden's Stennis, Eastland, and Byrd when they were legislating. And that is the opportunity to pick forums for political purposes. You'll notice that even though this is a federal matter, you have the recitation of the fact that California and New York law are involved in this. Florida law is involved in this, and that gives too many people with the wrong motivations too many opportunities to forum shop and find somebody in the many, many, many federal jurisdictions in the United States where they could get a jury pool that would allow them to satisfactorily persecute someone using lawfare. Now, there are things that I have heard during the course of this trial that do merit some investigation that are unsavory, but perhaps we went too far. And what I saw was not comfortable to me because it shows that we have lost that reliance upon human discretion being reasonable for the most part. And we have a situation where that discretion was abused. See, we have a thing in America called prosecutorial discretion. And that is a tradition that comes from English common law that says the prosecution has absolute discretion in the determination of whether or not a matter will be prosecuted or not. That assumes that a grand jury does not act independently, which on occasion it may. So we have, in one sense, a deviation from the flavor of American law because prosecutors over the last 4 years of the Biden-Harris administration elected to use their discretion to not prosecute certain things while using their discretion to briskly prosecute others. Now, you will notice that initially this whole thing started out as a 5-count indictment against Combs. Ordinarily, in a federal prosecution, that 5-count indictment will go on for 2 pages. This one went on for 14 in great detail, and there was a huge press conference wherein the federal prosecutors involved attempted to propagandize what they were doing as though they were trying to make a political statement for a political purpose. If you are adept at reading between the lines, what they were trying to do was fairly obvious. But that kind of thing is not appropriate. That same prosecutor's office against Mayor Eric Adams took a 5-count indictment and went on for what? Page after page after page with photographs of hotel rooms where it wasn't a crime scene. Hotels came up with all sorts of innuendo that they were using to basically throw somebody under a bus as a sacrifice to the political circumstances of the time. And that shows you what can happen with an abuseful situation. You have a similar thing that occurred with another celebrity, a friend of mine, Wesley Snipes, who was indicted in a federal district in Florida that he had never set foot in on a tax evasion situation where the primary target was the firm that prepared the taxes. And Mr. Snipes was one of 4,200 some clients of that firm, and he was the only one that was prosecuted. And they were trying to make an example of him because he was a celebrity. They did not get a conviction for tax fraud, but simply for failure to file the complete set of tax returns, which he had turned the responsibility for over to this tax company. It was the least of many included offenses, and it was also the evidence, and I was there as a witness during the course of these proceedings, that Mr. Snipes had not failed to pay his taxes. He was in a condition of having overpaid them, and IRS was presenting him with a $250,000 refund for overpaid taxes during the course of the sentencing proceedings. So he basically got jacked up due to incompetence of counsel, from my perspective, and also by manipulations of the circumstances. I can't say that about the attorneys in this case, but I do see that this is the kind of selective prosecution that leads to what is now termed lawfare, and that's not a good thing.
Right.
If any point it happened, it should have been left up to perhaps New York, if they had anything that actually occurred there, is a state matter, or Florida is a state matter, or California is a state matter, rather than trying to protect certain persons who were running from national office from potential embarrassment. So
Okay.
there you go.
All right. So, hey, there you go. We are all on verdict watch. So, and verdict, the jury deliberates Friday. They have the weekend. Maybe they come back with, well, they probably could come back with a verdict before Monday. Maybe a verdict would be in before Monday or goes into next week. So,
By the way, I can't see why this case was not a sequestered jury.
what is a sequestered
You
jury?
don't go home until it's over.
Meaning,
In other words, you stay in a government facility, usually a hotel. You're carefully guarded. What you get to read is controlled so you don't get influenced by outside sources. So you just can't call somebody up and talk about the case without anybody knowing about it. You aren't going to be able to talk about it with your family and friends. And instead of worrying about whether it's going on Monday, you just keep going and you take a break, eat dinner, come back and get to working on it. And then it's an agreed upon bedtime, go to bed next morning, get up, start at it again.
yeah. Uh,
Called sequestered jury.
well,
One of the most important things in your capacity as a citizen is to serve on juries. We judges congratulate jurors when they get through, and it's very seldom touched on, but we tell them, hey, this is just like volunteering for the armed services or coming in when you got drafted and doing your duty to protect the country. This is doing your duty to make sure that the country works when you do jury service. This is part of your obligation as a citizen to make your system work. And I hear so much talking about injustice, but yet the same people that talk publicly about injustice are the same ones that privately always want to know how to get out of jury service.
makes sense. Well, again, and I agree with you that why didn't they do that? That would have made more sense. So, but we'll have to just wait and see what happens. All right, I want to bring up Karmelo Anthony.
My reaction on that before we get into any of the technical discussions is this Anthony was supposed to be captain of his football team, right? Okay, the captain of the football team well, being captain of that football team meant that most of the players that you were captain over are not going to be black. Next thing is if you're captain of the football team, that pretty much means you are a starter. You're going to be either offense or defense. So whichever side you are on, that means that every play you line up with 11 people on the other side who may range from a medium size, 190 some pounds, 11 of them, all the way up to 250 or 260. And they're going to try to beat the crap out of you, which is why you have on padded helmets, shoulder pads, chest pads, rib pads, hip pads, thigh pads, knee pads. And people get hurt because they beat the crap out of each other. You're violent every play. Every play, you knock somebody down if you're trying to block. You get knocked down if you're trying to block and somebody's trying to rush over to you to get to your runner or your passer. You're catching a ball and you're getting tackled, or you're trying to tackle somebody. Every play you get hit. So the theory behind what everybody is hearing that's supposed to engender sympathy is there were 290-pound apiece twins that were going to physically hit him, suffer blows, the same blows that he would suffer every single play in a football game, by the same sized individual that he would be facing at least 11 of every play in the football game. And he's supposed to be justified in stabbing one of them in the chest and taking that person's life. That is a punk play. The entirety of the rationale from anybody who supports and tries to justify that, whatever the circumstances legally, that's sissified, and that demonstrates the widespread emasculation of the male population in the United States today, that such a position could even be considered. From my perspective, if you got confronted that way, either run, fight, take your behind whipping, or you prevail, or you sit there and hold your own so somebody says, we don't deal with this guy like that again. That's how humankind has been working since day one. We have an effeminized population of males in America who thinks they're too damn pretty to get scars, scratches, scrapes, bruises, or cuts because of unarmed combat, and they think they can kill somebody just because they might take a behind with it. That is a punk matter. That's not fighting like a man. That is fighting like a punk, and that is illustrative of something I saw growing up in what was once called South Central LA, but that was before I grew up. That was after I grew up, and that was the person that you had to worry about killing you, stabbing you, or shooting you was the scariest punk out there, who was full of fear. And that's what we have. Now, legally, there may be something that a jury might do in terms of nullification or under the charges that are delivered to them during the course of this trial that might result in an acquittal. I can't tell you, because juries are fickle animals. And that is just the reality of what we're confronted with our system, since it's not AI, and I doubt AI could embrace what's necessary. But it is what it is. But just as a masculine consideration, it was a punk play with no justification at all. Now, that said, let's move on to the other things that might come up legally.
This week, Karmelo Anthony, who is now 18 years old, has been indicted on first-degree murder charge. Anthony is accused of fatally stabbing 17-year-old Austin McCaff in April during a track meet in Frisco, Texas. If convicted, Anthony faces 5 to 99 years in prison. His attorney said he is looking forward to his day in court and for the full story to be revealed. Now, a judge has not been assigned yet. They said a judge should be assigned this week along with a trial date. And some people are speculating, hey, this trial may not even start until next year in 2026. But I want to bring this up here because Karmelo Anthony, a a spokesman for the family of Karmelo Anthony, launched into, you might as well say, a racial tirade after the 18-year-old was indicted Tuesday on first degree. Dominique Alexander, he is the founder and president of Next Generation Action Network, took to X to announce the legal process will move forward towards trial. This case involves multiple minors and sensitive details that I cannot and will not speak about publicly. That is why, from the beginning, I have refused to let this be tried in a court of public opinion. He goes on to say, Alexander then spoke directly to those he who says he have targeted the Anthony family. He says, to the racists, the bigots, and those filled with hate who've targeted Karmelo and his family, and even myself. You do not intimidate us. We are not backing down. This case is yet another example of what it means to be Black in America, where even our self defense questions scrutinized and politicized. My involvement, like many others, came as a direct response to the overwhelming hate, threats, and outside influence that have surrounded this case since day one. He also said he then asked Anthony supporters for prayers and support to support due process and to stand with us in the fight against white supremacy.
This here, that's bullshit. The problem is it's a punk play, as I elaborated on before I even started. There is no justification where there is, at worst, a fist fight and a behind whipping that might come out of that for stabbing somebody to death. None at all. That is a punk play, an unmanly play. To try and equate backing up that sissified circumstance with somehow or another impugning Black manhood as being jeopardized and necessary to be defended is ridiculous. Now, that's what the problem is. It's got nothing to do with race. It's got to do with punk emasculation.
Well,
And growing up, like somebody said, remember just the other night we had that thing on with X Space. What did that gentleman say? Growing up means you got to knuckle up.
yes. Now,
That's being a man, whether it is 15,000 BC in an ice age, or it's talking about right now, 2025 in the United States of America.
so he's implementing white supremacy into
That is garbage. I am insulted. And I've been Black doing stuff for Black folk longer than this fool's daddy had a gleam in his eye because his daddy wasn't even born when I started, and other folk who were Black men started being Black men. We know what that is. That's a punk play. And we always had apparitions growing up in somebody's hood, ghetto, or whatever it was in a segregated circumstances where you couldn't leave the place because you weren't allowed. There was always some punk that would go stab somebody, shoot somebody because he was scared instead of taking the behind whipping and then figuring out how to fight better or coming back and taking somebody one-on-one.
right. Now,
it's a disgrace.
What
I'm not saying that he might not get away with it, because depending upon how a jury is selected, depending upon what a jury pool is about, you may encounter a phenomenon in American law known as, quote, jury nullification. If I can give you an explanation, I had a series of trials as a defense lawyer. It's been more than 40 years ago. And the crime involved was called unnatural sex acts. It carried a range of punishment between 3 and 15 years in a state penitentiary, which at that time was up to the jury to impose. You know what the act consisted of? For heterosexual couples to voluntarily engage in oral sex could get you 3 to 15 years in a state penitentiary. So when I tried my defendants who were charged with such crimes, what wound up happening is the jury would say, Jesus Christ, my wife and I do that all the time. You mean we could go to the penitentiary? And the judge would say, yes, sir, that is true. Well, at that point, self-interest tucked in amongst the 12 people in the jury box who were there to deliberate. And they said, we don't care what the devil the law says. We're not going to convict somebody for doing something we do all the time. Now, that's a classic example of jury nullification. That's no longer the law in the state of Tennessee, but it was at the time. It's called unnatural sex acts. So we got a lot of jury nullifications when the jurors heard what that consisted of. Now, that's what may happen here if you get the right kind of jury for this case as far as the defense is concerned. This is what happened with Trayvon Martin and George Zimmerman down in Florida. You got jury nullification because the prosecution was not inclined to go against the majority of the constituents that elected the elected district attorney who wanted to return to his plush job. He went through the motions, and the family of the victim was represented by an ignorant attorney who did not realize that stand your ground was in favor of his dead client rather than in favor of George Zimmerman. And by the way, that person is now recognized as a preeminent civil rights lawyer. I'll say no more on that. I just thought it was a travesty, but I got consulted on the matter way back when, so it is what it is. Now, that's the kind of thing that can happen. I've had jury verdicts where I've looked at it and everybody in the place, multiple witnesses have testified as to the guilt of a particular defendant. And all of the rest of the witnesses have testified as to the innocence of a particular co-defendant in the same case. And the jury comes back with a verdict of guilty on what everybody has said is an innocent man and acquitted the person that everybody said did it. And it is ludicrous. The court has a question. Mr. Thompson, you're foreman of the jury. Is that correct, sir? Yes, sir. Will you please advise the court as to which one of these defendants the jury is identifying as John Doe and which one is being identified as Thomas X? Because the verdict didn't make any sense. I've had jurors come back on a closed case, and I've allowed the prosecution and the defense to question the jury, assuming the jury wanted to be questioned, and I've stood right there while it's going on. Mr. Foreperson or Ms. Foreperson, didn't you find reasonable doubt? Oh, we found lots of reasonable doubt. There was a lot of reasonable doubt in this case, but we figured that you smart trial lawyers kept us from finding out what really happened, so we voted to uphold the police. He must have done it if they arrested him. That's absolutely contrary to the law, and I set the verdict aside. But I mean, that kind of thing does happen. So, I mean, humans compose juries, and out of every 5 juries, 1, 2, 3 of them are pretty good. One of them acts like they have lost their mind, and the other one acts like they all took the short bus to school.
Okay. All right. That's it. Thank you, guys.
Meanwhile, the message, if you get summons to do jury duty, accept the call. Otherwise, don't say a damn thing about white supremacy, injustice, anything else, or justice is just us. You didn't do your job. And by the way, see, all it takes is one person to hang up a criminal jury. It's like part of what we've done is a man up thing, right? So when I'm talking about injustice for all, I'm also editorializing on that man up thing. And myself and other men that I know have spent lifetimes being men and answering the call and doing what we're supposed to do when we're supposed to do it. And we and myself, on behalf of them and on behalf of myself, are very offended when somebody starts trying to dig under and chop down manhood for a sissified position. I understand the legal possibility because right here, when you have a first degree murder situation, you have a case where the intent to take the life can quickly arise. So it becomes a matter of being an intentional and deliberate act. And personally, over the years, I was involved in at least 6 cases or trials where the death penalty was being sought against someone that was a juvenile who allegedly committed the offense. None of them got the death penalty. I saw to that. And I do have the dubious distinction of having gotten the youngest person in the entire world sitting on a death row, off a death row, after getting an execution stopped 23 minutes before it was supposed to occur. And the defendant at that time was 15 years, 2 weeks old. And this is for something he's supposed to have done when he was in the 7th grade. I got a unanimous decision by the Arkansas Supreme Court setting that verdict of guilty and the death penalty aside. So I do have that experience. Now, I say that in that context. Man up, brothers.
You hear me?
Oh, by the way, this is law, justice or injustice for all. I understand why a lot of people are angry about circumstances attendant upon their ethnicity as it is here in the United States today. But there is this thing called justice, and you should not let that get in the way, because justice is a thing. Justice is a circumstance. Justice is a state of mind. And if you're going to go out and get vengeance, that's on you. Just don't expect the system to back you up when you start trying to subvert it to cover up for something that's got other explanations besides justice.
All right. And I want to say thank you, everybody, for tuning in to Injustice for All with Judge Joe Brown. Please share and like this video. And most importantly, please comment below and share your thoughts on today's video. And we will see you in the next video. Bye.